I think before the exit, there were around 20 participants. We'll just wait if for a couple of minutes if the others will join. We have 15 as of now. I think we can start because it's just 18. The others I have not joined yet, so we'll go ahead.
Yes, sir, we can start.
Yeah. Okay. So, yeah, welcome everyone to the session on interplay of IBC with the Prevention of Money Laundering Act. So, before we run into the topics, I just want to spend a minute to explain, or rather, just express as to how this both acts have been enacted. Now, there are legislations where the legislation is meant for a specific aspect. That is, it is meant for addressing providing for a procedure for a specific issue. And there are legislations which are provided for special purposes. Now, both these statutes, IBC as well as PMLA, both per se fall within this ambit of special statutes. Now, these legislations have been enacted with specific purposes and both these enactments are meant to be going in line in terms of its implementation. Now, with this brief backdrop, let's try to look into what we are capturing today as part of this session. So, in the session, we will discuss as to what are the three stages where this becomes applicable and what are the applicability of this uh, uh, discussion with respect to PMLA. There are three different stages. We'll look into that. Then we'll also try to understand what is the role of PMLA appellate authority. Then we'll look into the interface between IBC and PMLA. What does the Delhi High Court opine on the role of IBC and PMLA? And then we'll dwell upon certain case laws. And finally, we'll open the floor for discussion. And I feel this open discussion is something which should help all of us as professionals to give our own experiences in our own cases. At the same time, it should also help us in giving a new dimension of thought process on the existing problem. Now, when I say the existing problem, I intentionally mean it to be a problem because today there is still no settled law when it comes to interpretation of issues happening during the CARP with respect to attachments under PMLA. There are orders from Delhi High Court. There is an order from Bombay High Court. But overall, there is no set principle in terms of how this PMLA and IBC has to pan out. Now, there is one case which I recollect now, which probably has a great bearing in terms of the jurisprudence, and the Supreme Court is yet to pass an order. So in JSW case, where JSW had acquired an asset, and the majority of the assets which are acquired in that corporate debtor by way of resolution are under attachment of ED. However, the creditors had immense pressure because the plan got approved, but the RA is not willing to implement the plan unless the ED releases the attachments. Now, at that juncture, the RA had no other option but to take over the company by making the payment to the creditors. Now, what did the RA do? The RA that in an event there is a adverse order by the Honorable Supreme Court, pursuant to which the ED attachment stands valid, which technically means the entire assets of the corporate debtor are gone. In such a situation, the creditors shall refund the monies paid to them. That was the kind of a understanding the RA had with the creditors, and subject to that, the RA made the payments to the creditors. Now, this is the one situation, and this is a case which is sub judice before the Honorable Supreme Court for more than 1.5 to 2 years, if I'm not wrong. Now, this is how complex this interpretation between PMLA and IBC is going to be. Now, let's understand what are the three stages of applicability where we need to dwell, when we need to break up brains in terms of understanding the applicability. And in the same area, I'll also try to throw some more light on how the PMLA operates. So the three stages of applicability are: 1, prior to CARP; 2, during CARP; and 3, after CARP. Now, what do I mean by prior to, during, and after? I mean prior to CARP, where the assets are attached prior to the commencement of CARP, that is prior to the insolvency commencement date. So if the ED had attached the assets even before the insolvency commencement date, and subsequently CARP is commenced, then what happens to the nature of such attachment? This is one thing which we'll have to understand. Second is during the process. Now, there is a possibility that after you have taken over this, after the RP had entered as a resolution, after the RP had taken over this company as a applicant, as a resolution professional, and the RP is running the show, and during that time, an attachment has been imposed by the authority, by the PML authority. By the ED, Enforcement Directorate. Now, what happens in such situations? At the third stage is after the plan is successfully implemented and approved, and still ED comes back and passes an attachment order. That is after the attachment has been ordered after the CARP, that is after the successful completion of CARP, assuming successful resolution by way of a resolution plan. Now, these are the three different stages and three different complexities we need to understand in the entire process. Now, when I talk about three different complexities, first let us try to understand the stage where we have a let us look at the stage of prior to CIRP. Now, prior to CIRP, or even whatever be the stage, generally the attachment of ED is made on tainted assets, right? Now, what do we mean by tainted assets? So, if you see, the very act is named on prevention of money laundering. Now, what is money laundering? Where the monies which are not accounted for, in the sense they are not coming under any of the books of accounts, and they have been diverted from the books in order to build certain illegal assets or tainted assets which ought to have been brought in the books and which ought to have been taxed, right? So when you divert such funds and when you launder such money, that's where PMLA comes into picture. Now, let's take an example that as per as per the analysis of ED, one of the properties of the corporate debtor has been, has been attached because the corporate debtor has involved in certain activities of money laundering. That can include, let's say, there has been a huge amount of loan taken from one of the, I'm just giving you a classic example of what happened in S Bank and DHFL, where a lot of monies have been provided as loan to certain entities, which have in turn invested such given loans to its subsidiaries at a very high, at a different interest rates and all, and try to divert the funds among various companies. Now, there is and subsequently what they do, they they write off those loans saying that it is completely bad debt and all that. So there is a way they launder the funds. So now if ED had got the trial and ED believes that, okay, this company is involved in money laundering and therefore let us attach these assets, which are properties of tainted assets, and which are kind of output of such kind of a tainted money or whatever. Now, this is the role of the ED. So the role of the ED is to make sure that such kind of tainted assets are not going into the hands of any promoters or any directors or any persons or any companies, and it has to be the property of the country. So that is the role of ED. So now, prior to the CIRP, yes, if the ED during its investigation has realized such thing had happened, the ED can attach such property. Now, what are the complexities? The complexities are that such properties would have already been attached to the secured creditors. Now, it is possible that secured creditors would have been given security interest over such properties. Now, that's where the difficulty comes with respect to enforcement of security interest under SARFAESI versus this PMLA. Now, that also is a completely parallel subject, which is of paramount importance. But we'll stick to IBC for now. So coming back to the IBC, where prior to the CIRP such attachment had taken place, now till the time insolvency commences by way of admission of a CIRP application, there would not be anything legally possible for the company to do apart from fighting under the PMLA code, right? So technically that's the situation. Now let's imagine, okay, prior to CIRP, ED has attached the properties, and subsequently the RP has been appointed or IRP has been appointed. No, the IRP, when he steps into his role after the admission of the application by the NCLT, the IRP will realize that, okay, these are the assets, but these assets are attached with the honorable and attached by the ED. Now, having realized that the attached are attached by the ED, the IRP will intimate the same to the COC and, even in the information memorandum, EOA, etc., etc. Now, the question is, can such attachment continue even during the CIRP process? Now, this is what is the first question we need to look into in prior to CIRP stage. Can the attachment continue even during CIRP? Now, to answer this question, we need to understand as to why we have a confusion, or rather why do we even look at this situation as to whether this attachment can continue or not. It is because of the provision of moratorium. So moratorium under section 14 of the code provides that there cannot be any enforcement of security interest by any creditor, and it technically it says do not hamper with the rights of the CD or over its assets. Let the CD operate within a protected shell of moratorium. That's the whole intention of moratorium under Section 14. So the contention of the RP can be that, fine, you have attached the property before CIRP, but was now the CIRP is ongoing. There is a Section 14 which provides for moratorium against the assets, moratorium to protect the assets of the corporate debtor. Since there is a moratorium to protect the assets of the corporate debtor, I don't think it's right for you to continue your attachment and therefore release the attachment. Now, this was pretty much possible. I mean, I'm not saying this is possible. This was pretty much done by a large number of RPs in their cases, wherein they filed for release of attachments during the CIRP on the ground of moratorium. Now, what happened to such cases? That is something which we'll have to look into. That is step number 1. Now, step number 2 is with respect to during CIRP process, the stage 2. We'll get back to where we left in stage 1. Now, during CIRP, what happens during CIRP? During CIRP, the assets attached, assets are attached even when the moratorium is in force. Now, prior to CIRP or during CIRP, there are two questions. One, firstly, if the attachment happened before CIRP, then can such attachment continue? Second is, can such attachment be done during the CIRP when the moratorium is in force? Now, let's dwell upon these two questions before we move to the next. Now, coming to these two questions, in basically the Delhi High Court had clarified in one of its orders, and which was relied upon by the by the Honorable NCLAT, that wherever any such kind of an attachment is being provided for, is in such a case, the Honorable NCLAT, relying upon the order of the Delhi High Court, had stated that the IRP or the RP or the liquidator, depending upon what kind of a situation or position the case is, they have every right to approach the authorities under PMLA. So technically what this says is that, I mean, the majority of argument of the RPs or the councils of the RP is that the IBC should prevail and all these assets should be handed over to the RP. But the NCLT and NCLAT particularly had strongly affirmed its position based on the ruling by the Delhi High Court in the case of Axis Bank, that there is, I mean, wherever there is any cause of action where an attachment has been done, Section 14 of IBC would not help, is what the Honorable NCLAT had ruled, right? The Honorable NCLAT had provided that basically PMLA is a special statute and therefore it should be specifically implemented. And with such kind of an implementation, the RP or liquidator should be free to move to the authorities under PMLA and argue the matters there before they can come forward and do anything before the Honorable NCLAT. So technically what NCLTs and NCLAT have taken a stand is that they have no role in directing the ED to release the attachments. You need to go to the PMLA authority and argue your matters there. That's what is the current position with respect to attachments, where NCLAT categorically held that Section 14 of the IBC, the moratorium under Section 14 of the IBC, will not come for any help in terms of attachment of a property which is criminal in nature. See, though the procedure of attachment is a civil in nature, but the attachment per se and the nature of it is purely criminal because of the kind of money laundering which is involved in allowing in attaching such kind of an asset. So this is something which we need to know, that a moratorium per se will not be in a position to help the RP in taking it as granted to get the attachment released by the ED. So this is something which we need to understand. Now, as we move forward, the next stage is after the completion of CIRP. Now, this is a bit tricky. Once the CIRP is completed, till then, let's assume there is no attachment. Now, after the CRP, the ED's investigation has come to an end. And ED realized that there are certain assets of the corporate debtor which have to be attached. And let's assume for a fact ED had passed an order of attachment. Now, whom is this attachment binding? It is binding the new resolution applicant because the new applicant is actually taken over the resolution over the corporate debtor. So technically, the new resolution applicant is holding the equity in the corporate debtor. So this will hamper the entire concept of resolution and clean slate because after the plan got approved, the resolution applicant is still facing certain problem in terms of criminal liability. Now, in order to safeguard the resolution applicant from such kind of a provision, from such kind of a situation, the lawmakers have introduced something called as Section 32A. Now, Section 32A of the code has provided that there has to be criminal immunity to the resolution applicant, or rather to the assets of the corporate debtor once the resolution has been approved by the Honorable NCLT. So it very clearly says that either by way of approval of plan by the NCLT or upon passing of order of liquidation by the NCLT, sale of assets in the liquidation process, such assets shall not have any criminal liability. Rather, they will have criminal immunity. There cannot be any attachment, seizure, or any of such nature of orders passed against such assets is what it categorically holds. So Section 32A per se is a powerful section which has a huge bearing in terms of implementation of the or protection to the resolution applicant. Now, recently the Bombay High Court in March 2024, the order was pronounced on 1st March 2024 in the case of Shiv Charan and others versus adjudicating authority and another, wherein the Bombay High Court had interpreted the provisions of Section 32A, and by relying on provisions of Section 32A had held that upon an approval of the resolution plan, the 32A will come into picture and the attachment shall be released if they were there before, and particularly there cannot be any attachment on such properties which are subject matter of a resolution plan and the plan is approved under plan under IBC and pursuant to which Section 32A comes into operation. Now, this kind of an interpretation has been taken by the by the Bombay High Court recently in the month of March of 2024. So this is the current position of law in terms of the rulings passed by various courts. Now, let's try to dwell upon certain interesting aspects. One second. Yeah. Now, let's try to dwell upon certain important aspects under the role of one second. Yeah. Now let's understand the role of PMLA Appellate Authority. In fact, we have already discussed this role of PMLA Appellate Authority. So we'll skip that because as I was telling, the Honorable NCLAT had clarified that the Appellate Authority, the authorities under PMLA shall continue to operate even during CIRP, even when there is a moratorium. When it comes to the release of properties by the ED or any such prayers, it is the PMLA authorities, including the PMLA Appellate Authority, which has got the jurisdiction, and not the NCLT or NCLAT is what has been held by the Honorable NCLAT. So therefore, the PMLA authorities currently continue to have their role when it comes to interpretation of issues or giving reliefs under PMLA. Now let's understand how IBC and PMLA coexist. Now, this is the order of Delhi High Court in the famous ruling of the Axis Bank, wherein the High Court had held that the legislations like that of PMLA, the recovery of debts due from banks, and also the SARFASI. So all these acts, and including the Insolvency and Bankruptcy Code, it says that these legislations must coexist. So this word coexist is extremely important. So the idea is that none of it can override other, all of it coexist in a similar space, each to be construed and enforced in harmony. Now, the interpretation to be provided for a matter where there is kind of a interpretation, where there is kind of a reliance on the other legislation as well, then a harmonious interpretation has to be introduced by which the greater good has to prevail. So usually when you do an harmonious interpretation, it's always important to understand what is the greater good or what is the what can in every situation it gets different, it gets varied. So that has to be looked into. Like for example, let's say one of the promoter himself or herself had become the resolution applicant through one of its entities and they have taken back the company. Now, over here, should such a promoter be given the protection under Section 32A? The answer ideally is no. And even Section 32A clarifies that where it occurs only when there is a change in management or there is a there is no relation between the existing promoters and the RA. So if at all there is any relationship which can be established, then definitely the protection under Section 32A may not go to the resolution applicants. So the law is trying to provide that the moment a resolution is passed, we are definitely there to provide certain immunity and give that comfort to the resolution applicant. At the same time, that provision cannot be misused by the promoters, and therefore there is a prohibition that the existing promoters, when there is no change in management, Section 32A will not come into picture. So that's something which we need to understand. So firstly, it has to coexist, and secondly, it has to be construed and enforced in harmony without one being in derogation of the other. With regard to the assets respecting which there is material available to show, the same have to be derived or obtained as a result of criminal activity related to a scheduled offense and consequently being process of crime. So basically what it tries to say is there cannot be any derogation of the other, and particularly when there is a cause of action established under PMLA, the PMLA will definitely have a role to play when such kind of an asset is a proceeds of crime, right? So this way the Delhi High Court had clarified that there is nothing of a overriding nature between these legislations. All these legislations must coexist, and wherever required, the same shall be construed and enforced in harmony. Now, this is the current position with respect to interpreting IBC and PMLA. So, whenever we talk about IBC and PMLA, the intention is not to look at how do we overrule the other legislation. The idea is not to say which legislation prevails over the other. The idea of a interplay of IBC and PMLA is to highlight the fact that none of the legislations are overriding the other. It is that both the legislations are running in harmony when it comes to a situation of a company undergoing CIRP. However, where we see the recent orders, we tend to form an opinion that IBC kind of prevails over PMLA. But I feel it's not correct for one to use that statement that IBC will prevail over PMLA. Based on the facts of the situation and based on the legal provisions provided under the code and the PMLA, the ruling or the outcome of a particular case and a dispute will vary. That's something which I wanted to highlight. Now let's run through certain case laws. The first is with respect to High Court of Delhi order passed in the year 2022 in the matter of Rajiv Chakraborty versus Directorate of Enforcement. Rajiv Chakraborty is an insolvency professional and the RP of that case, EAEC, and versus Directorate of Enforcement. The main contention in this case is that what is the impact of a moratorium under Section 14 is what is mainly deliberated in this case. And does it have any powers on the ED to enforce an attachment under PMLA? So, like whether the moratorium will come into the way of ED enforcing an attachment under when the company is undergoing CARP is what is the main contention. And this relates to our pre-CARP stage and during the CARP stage. Now, in this case, the RPS Council contended that ED will not have any jurisdiction to interfere once a moratorium comes into picture, and also that the PMLA will always be superseded, or rather the IBC will overpower and override the provisions of PMLA. And as a counter to this, the ED had contended that the IBC provisions cannot be used as an amnesty route, that is to override for an accused under PMLA. And if that contention were to be accepted, it would defeat the very objective informing the confiscation regime under the PMLA. So the ED was of the opinion that if the concept of moratorium is something which is, or rather the provisions of IBC shall are being considered, and ED is curtailed from passing an attachment order for proceeds of crime, that would defeat the entire idea of confiscation under PMLA is what the opinion of ED was. And subsequent to hearing both the parties, the Honorable Delhi High Court had held that uh, whenever any attachment of a PMLA is being done, the provisions of moratorium should not come into picture, is what has been held by the Honorable Delhi High Court. Now, it's a 124-page order, so I just tried to keep it as simple as possible. But in this case, also relies on its previous judgment. The Delhi High Court had passed a previous judgment in the matter of Axis Bank. So it also heavily relies on its orders in the Axis Bank judgment, wherein it kind of clarifies that wherever an order is passed by the ED under PMLA, it should not ideally result in a situation where the RP or the corporator is facing any difficulty. So it provides that there are certain, I mean, it says that you can, as an RP, approach the authorities under PMLA for whatever be the reliefs you want, which may be legally permissible. So the law tries to highlight that there cannot be a set principle to say this is not right or not wrong. On a case-to-case basis, there are authorities under the PMLA which can be looked into, right? And which can be approached with the grievances of the RP. That is something which has been clarified in this by relying on Axis Bank judgment of the Delhi High Court. And secondly, it also clarifies that any such provisional attachment order provided by the ED under the PMLA will not invest in that authority a superior or overriding right in the property. So it also tries to highlight that merely by way of giving the attachment, because an IBC is in picture and because there is a need for an harmonious interpretation, the ED should not be given overriding rights to dwell in, I mean, to interfere with the property or to have a superiority over the rights in the property. So that's something which has been provided for. And it also says that any claims of parties over the property that may be attached and the question of distribution and priorities would have to be settled independently and in accordance with law. So there is, of course, it's not providing any clarity, but at the same time, it is giving an open-ending situation where the distribution, that is, this purely talking about distribution under resolution plan to a secured creditor, or distribution under liquidation. I mean, whenever you go for liquidation, sale of such assets which are under ED attachment, but are also secured to a secured creditor. Now, how both of it pans out is something which has to be next. Yeah. Then, so this is only the, I mean, this is basically the aspect under the order of Rajiv Chakraborty versus ED, wherein the High Court observed that the power to attach under the PMLA, would not fall within the provisions of, would not fall within the ambit of section 14(1) of the code. So that's what this case law is about. As we move forward, the Srei Infrastructure Finance Limited matter held in, I mean, decided by the NCLT Mumbai in 2019. So this case law I wanted to insert only to provide an insight as to how it was interpreted during the initial years of IBC. Now here the main contention was to withdraw the properties attached by the ED under PMLA. It's particularly because the CRB has commenced and RP must take charge and custody over the assets in accordance with section 18 of the code. So the contention of the RP is that, see, as an RP, I am supposed to take charge over the assets under section 19, section 18, and therefore the ED has to withdraw its attachment. And it is also contended that because there is a 238 non-obstante clause under the IBC, the adjudicating authority under the PMLA could not have continued with the attachment of property. So their intention is the moment there is a non-obstant clause, IBC shall prevail. So the adjudicating authority under PMLA shouldn't have passed or continued with the attachment of property. Now, now let's see what the court had held. The court had held that the IBC provisions will prevail and RP must take charge of the assets. Now, this case law, as I said, I only wanted to give you how the NCLTs were interpreting this in the beginning years of this contention of attachment of ED versus IBC. However, subsequent to this is where we got the Delhi High Court order. Now, this order, as I said, is trying to straightforward say that the provisions of IBC will prevail over PMLA and RP must take charge of the assets. However, this is not the current position of law in terms of how the ED attachments has to be looked into. So, as on today, subsequent to these cases, based on the jurisprudence which has evolved from the order of the Delhi High Court in Axis Bank matter and subsequently the Honorable ANCLAT, today, if there is any such attachment, then the RP shall approach the respective authority under the PMLA with the relief on how the RP is intending to deal with the tainted properties. So that is what is the position of law. And therefore, these kind of orders, if you come across passed somewhere, should these kind of orders are ideally would have been passed in the span of 2018 to 20 or before 19 actually. So or during like before the mid of 19. So these kind of orders, if at all you are coming across during your practice, these are something which should ideally be ignored, particularly because these orders have not, I would say these orders are not sufficiently dealt with the position of law, and subsequently all these orders are deemed to have been overruled with respect to the orders passed by, subsequent to the orders passed by the Delhi High Court and Bombay High Court and other other orders passed by the Honorable ANCLAT. So these cannot be taken these orders cannot be taken on the basis on which you build your case. So as I was discussing, the Rajiv Chakrabarti versus ED order is of paramount importance, read with the Axis Bank judgment. And we'll also deal with one detailed judgment, which is Shivcharan and others versus adjudicating authority. This is ordered as recently as on March 1st, 2024. But before that, let's look into the High Court of Allahabad order in Nirmal Singh and others versus State of UP. This was also passed in 2024. The contention in this case is, since CARP has commenced and the RP was appointed, the dues made by the applicant must be paid by the RP and that any liability of the company has to be recovered under IBC. Now, in this case, the court had lifted the corporate will and made the promoters liable and held that as per section 32A, the criminal liability and prosecution of the promoter shall continue and no benefit of IBC shall be given to them. Now, in this case, what they tried to do is that because there are certain orders of dues payable by the applicant, that is the promoter, by virtue of criminal offense of the company, and because such kind of an order has been passed, because such kind of order has been passed against them because of the criminal actions of the company, the applicant, that is the promoters, have prayed that all that which they made shall be paid by the RP. And because this is a liability of the company and not their personal liability. However, the court held that, boss, you are the culprit behind the criminal liability and you are personally liable for the criminal actions, and therefore they lifted the corporate wheel and made them personally liable to make those payments under section 32A of the IBC. So this is just to give a different tangent to this 32A discussion, because we tend to forget the fact that the ED does not just make the company a respondent, it also makes all the directors and others who are involved in the crime also parties to the case. Now, in such an event, when the company is being rescued under section 32A under IBC, the promoters still continue to be made liable. So in this case, the promoters have contended that we made certain dues because of the offense committed by the company, and therefore the RP must repay all those dues back to us with respect when since the plan is getting implemented and it has to be recovered under IBC. However, the court, the High Court of Allahabad had clarified that the criminal liability will continue and there cannot be any benefit of IBC and it provided to the promoters of the corporate debtor. Now let's look at the recent order of the Mumbai High Court. This, as per me, has been extremely interesting. So before I go to the contention, let me run you through the various facts in this case. The facts of the case are that there is an order of ED even before the commencement of CIRP, and subsequently CIRP has commenced. And after commencement of so there is an order of the ED, and subsequently CIRP has commenced. And after commencement of CIRP, the RP was appointed, and like almost after 2 years after the PMLA has passed the order of attachment, the RP was appointed. And after the, I mean, like CRP was admitted. And after the CRP was admitted and RP was appointed, the RP had invited the plans, even when the attachment was pending. They have invited the plans, and the Honorable NCLT in 2023, February 2023, the Honorable NCLT approved the resolution plan. Now, in the resolution plan approval, the NCLT ruled that by virtue of Section 32A, all these attachments of the ED shall be released. So now the challenge which the ED had done, or rather the ED had appealed for, and there was various orders the ED had passed and all that. So I mean, ED had appealed for is that firstly, there cannot be such kind of a authority upon the NCLT to direct the ED to release the properties. Right? So they have hellbound on the fact that the NCLT should not have ordered for release of properties, claiming that the NCLT does not possess such kind of an authority. Then the next aspect is with respect to the fact that the attachment is with respect to the criminal proceeds, and therefore setting aside such kind of an attachment would hamper the interest is what is the other contention of the ED. Now, countering all of this, the Delhi High Court had interestingly held that, had declared that, rather, had held that the NCLT was within its jurisdiction in declaring that the CD would stand discharged from the offences alleged to have been committed prior to CIRP and by relying heavily on Section 32A of the code. In my opinion, and in my limited experience under this, there has not been an order where Section 32A has been interpreted the way this order has interpreted it, or rather relied upon. So Section 32A actually provides for complete clarity in how the criminal immunity is provided to the corporate debtor, but for some reason it has not been quoted heavily in any of the other orders. Now, in this order of the Bombay High Court, the entire reliance has been placed on interpreting how Section 32A will be protecting the resolution applicant. So it tries to say that the because Section 32A says that upon approval of a resolution plan, the criminal attachment and all will be deemed to have been released. So it clearly says since the approval of authority resolution plan is within the authority of NCLT, and therefore NCLT is definitely having a jurisdiction to declare that the corporate debtor will stand discharged from the criminal offences and that the properties shall stand free of attachment from the approval of the resolution plan. These kind of observations can be made in the resolution plan is what the Honorable Honorable Delhi High Court had ruled. Secondly, they clarified that the jurisdiction of Section 32A of the IBC, right? It clarifies that the 32A will come into picture or will be attracted the moment a resolution plan is approved under Section 31 of the IBC. So that it very clearly says that all the protections under 32A will be offered only when a plan is approved by the Honorable NCLT. Next, it further tries to say that it supports the provisions of Section 32A to state that it is clear, logical, and reasonable. Now, this I feel has to be underlined and relied upon because as insolvent face any kind of a issue wherein the the Bombay High Court had opined with clarity that Section 32A of the code is clear, logical, and reasonable. And then it talks about how it helps, or rather, how it is reasonable. It states that the attachment of the ED under Section 5 is a measure in aid of eventual potential confiscation under 8. So it says that there can be confiscation of the property only when the CD is convicted for an offense of money laundering. However, the same section, because see, the section 5 and 8 of PMLA provide that where the CD is convicted of an offense, the property has to be confiscated. Now, section 32A provides that there is an immunity to the CD from such prosecution. So it technically means there is no possibility of a conviction that can be followed. So where there is no possibility of a conviction to be followed, there is no possibility for you to continue your attachment. So how they have interpreted is that as per section 5 of PMLA, there is an attachment, subsequently there is prosecution, and then you are convicted of that offense, then your property will be confiscated. Now, if the property had already been confiscated, then there is a different story. Then all of this interpretation will not come into picture because your property has already been confiscated. However, here, what we are dealing in all of our cases under PMLA and IBC and the disputes is the asset has been confiscated, asset has been attached but not yet confiscated. So, since it is attached, and as per section 32A, there cannot be a prosecution. Therefore, there is no possibility that a conviction can follow. And since there is no possibility that conviction can follow, it is logical that the corporator should have the protection from any such continued attachment. And hence, Section 32A is logically trying to say that the property should go back and there has to be immunity. And that's the only way you can resolve such kind of an assets. So that's something which has been opined by the Bombay High Court in this order. And they're not talking about the implications of moratorium that has been clarified, that there is no concept of implementation of moratorium. And while they hold that 32A will not come from the date moratorium is in place, they mean that the moratorium will come to end, and subsequent to the coming of end of moratorium, 32A will come into picture. So they didn't go into the aspect of dealing with Section 14, since they are purely reflecting on this case based on the interpretation of Section 32A, considering that the resolution plan has already been approved. Now, they also categorically held that the ED should release the attachment as a consequence of Section 32A of the code. That has been laid out in the order. Next, the ED, there's this one more observation where the Honorable Bombay High Court had held that with effect from the approval of the resolution plan, that is in this case, February 2023, it is deemed that all the attachments have been released. So the order of the NCLT approving the plan shall be communicated to the ED so that the ED can act upon releasing of the attachment, is what the Honorable Bombay High Court had held in this matter. Now, for me, this case is a classic example, or rather illustration, of how 32A has to be interpreted in order to provide immunity to the resolution applicants. And secondly, it also holds a special position in terms of the PMLA to state that the ED cannot per se override or go in terms of continuity of attachments and interpret Section 32A differently. clarifies that 32A sets a closure on pending investigations or attachments with respect to the property. You can definitely continue the investigation against the company, and the company can provide all that information which it needs. But the attachments per se shall be released is what this provision, this particular order tries to highlight. So now that we are referring to this order in great detail, and we are as part of the order, as you may understand, we are purely relying on the interpretation of section 32A. So let's spend a moment to understand what 32A is, so that we'll have a great clarity on looking at these provisions from, or maybe subsequent to this, we can have a detailed discussion on how this section 32A can be interpreted. So just a moment. Yeah. So section 32A starts with a non-obstante clause to say that notwithstanding anything to the contrary contained in this code or any other law for the time being in force. And then it talks about the liability of a CD. It says the liability of a corporate debtor for an offense commenced prior to commencement of CRP. Now, this is extremely important for us to know that these attachments should have happened for the offenses committed prior to the CIRP. Where the offense is committed during CIRP, this kind of a protection will not be provided for, and it is assumed that usually the RPs will not do such offenses during the CIRP. However, the as liability of a corporate debtor for an offense committed prior to the commencement of CIRP shall cease. The language used is very clear. It shall cease. And the CD shall not be prosecuted for such an offense. Now, these are the two aspects based on which the Bombay High Court had relied heavily on and tried to conclude that the section 32A provides a complete closure of in terms of attachment. So it's like there shall be a seizure. I mean, the liability will cease. The moment liability ceases, the CD shall not be prosecuted for such offense. So if the prosecution is on, you should stop the prosecution. It cannot be prosecuted for such offense from the date the plan has been approved under section 31 of the code. And of course, when the resolution plan results in a change in management or control of the CD to a person who is not a promoter or who has a reason to believe to have the conspirate for such kind of an offense. So ultimately, the idea is to say that the management who is taking over this company under IBC by becoming a resolution applicant should not have any relation of whatsoever nature with the RP or with the I'm sorry, any relation with the promoters or the management of the company or anybody who would have abetted in the committing of such kind of an offense. So there has to be completely new management which is stepping in. That's the requirement under section 32A. And subsequently, it says that if at all, if you see the proviso, this is again absolutely clear. It says if a prosecution had been instituted during the CIRP against such CD, so which means it is giving an enough right for the ED to institute a prosecution during the CIRP. However, it shall stand discharged from the date of approval of the plan subject to requirement of the subsection having fulfilled. So, the moment the plan gets approved, the entire prosecution shall stand discharged even when there is a pending prosecution. Now, isn't this a language which is clear enough or good enough to close the complete position with respect to continuation of attachments under the IBC? Yeah, close to that, right? So, but there are some other provisions under 32A which we need to look into, which will give much further idea. Now, subsequent to this proviso, it clarifies that though the company's criminal actions are being, there is an immunity provided for the company's criminal actions. This proviso clarifies that where there is a partner or a officer who is in default under the Companies Act, they shall be continue to be liable to be prosecuted and punished for the offences which they have conducted, notwithstanding that the serious liability has ceased. So the individuals who were part of the committing of such crime will continue to be held liable, but the company per se will be free from all its liability and also from the prosecution. Then next most important thing for us is subsection 2. The subsection 2 says, so subsection 1 talks about no pending prosecution, and any cause prosecution shall not continue and any liability shall cease. Now subsection 2 says no action shall be taken against the property of the CD in relation to an offence committed prior to the commencement of the CIRP. And where such property is covered under the plan approved by the adjudicating authority under section 31 or sale of liquidation assets under chapter 3 of the code. So wherever there is a plan approved and this property is covered under that plan, in such an event, no action should be taken against the property of the CD. Now, this is what has been provided for. Now, what is meant by no action to be taken? That is being clarified. In the explanation, they clarify that an action against the property of the CD in relation to an offence shall include attachment, seizure, retention, or confiscation. So you can neither attach, seize, retain, or even confiscate the property for whatever be the ground. As and when this property is belonging to the CD and it is part of the resolution plan under section approved by this NCLT under section 31 of the code. And second, it also talks about, and second, it again clarifies that it will not, this kind of an immunity is not to the individuals who have acquired the property, and it also tries to clarify that such kind of a provisions will continue against such individuals. However, finally, under subsection 3, it provides that though there is a criminal immunity provided, the corporate debtor or the individuals who are like the new management of the corporate debtor should cooperate with the investigation authorities is what subsection 3 clarifies. So section 32A is divided into three subsections. For subsection 1 is talking about seizing of the liability and non-prosecution of the offences. Subsection 2 talks about no action to be taken against the property, including attachment, seizure, confiscation, or retention. And subsection 3 talks about the fact that though there is a criminal immunity provided, the CD should still continue to extend all of its assistance and cooperation to the investigation authority to further investigate on the offense. So this way, section 32 has been clearly laid out, and this section 32 has been heavily relied upon by the Bombay High Court in interpreting the requirement, the Bombay High Court in interpreting the recent case in 2024, where the NCLT had passed an order in February 2023 approving a resolution plan. So this is how section 32 has been devised, and the Bombay High Court has relied on the same in a recent order. So these are the issues which I felt are extremely relevant when it comes to PMLA, particularly with respect to attachment by the ED. Now, on a practical case, the case-to-case situation might vary. Like this reminds me of one of the cases in the liquidation assets, in the liquidation, where the asset was under attachment by the ED, and the liquidator wants to go on sale of that particular asset with a full disclosure that this asset is under attachment of the CD, of the ED. Now, the challenge is before the NCLT, they went for a permission to go for such kind of an asset, subject to condition that if the asset is sold successfully, then using the provisions of section 32, using the provisions of section 32A, the ED should mandatorily release the attachment is what the section, is what has been expected by virtue of the prayer sought by the liquidator. So the liquidator sought a prayer that if the buyer is buying out this asset under liquidation, then subsequent to that sale, the asset shall be deemed to have been released from its rigors of attachment. Now that has also been allowed by the NCLT, but subsequently again it has been subject matter of litigation. So there are multiple NCLTs and forums being approached by various resolution professionals for their relief. However, there are various issues which still remain open for the resolution professional to handle. So with this, I open the forum for discussion, And anybody who would like to share your experiences in your process as a insolvency professional and your challenges, you're welcome to share your views. And or if anyone wants to add any further to what has been discussed, we can do that. Or subsequently, or maybe if any of you have any of the queries in my presentation or in general under PMLA or IBC, please, you're welcome to share the same and we can discuss in this open discussion. If none of us have any further queries, then I think we can conclude the session. But if any of us have any queries with respect to this, let's use this forum to discuss our queries and to discuss this open-ended topic.
So, what is the clear position now regarding this pre-CRP, post during CRP, and post CRP? If there is
Yes, sir.
anything, so what is the clear position? If there is prior CRP, if any
Huh.
proceedings were going on, and
I'll tell you.
if it that means it will continue, and it can
Yes.
materialize in seizure of assets by ED.
Yeah, it can materialize an attachment of assets by ED. Definitely, even during CARP, they can attach, or prior to CARP, they can attach, and it can still continue during CARP. And first and foremost, clarity is Section 14, the moratorium will not per se set aside the attachment order. That is the clarity provided in various orders till date. Second is that where the RP feels there is a ground to get the ED attachment released, the RP is free to approach the authorities under PMLA, not under IBC. The reason is that both of these legislations coexist and has to be harmoniously interpreted, and therefore the NCLAT had opined that neither the NCLT nor NCLAT will have jurisdiction to hear about the attachments made by ED and to order the ED or direct the ED to release the properties. Since there is a specific authority to deal with such attachments by the ED, the RP shall approach the relevant authority is what has been held. And that is what is the current position now, that any RP who wants to challenge an order of attachment by the ED shall approach the PMLA authorities and not the NCLT or NCLAT. Now, that is another position of law as of now.
So, is there
Next, yeah.
any such ruling by PMLA? Sorry, that yes, the PMLA court that if any RP has gone to PMLA court and got the attachment removed,
Yes. Uh,
is there any such court case in PMLA
yes,
given
sir.
straight yes verdict in favor of the
RP.
assets being removed from attachment?
Yes, sir. There recently, I think the High Court, Bombay High Court order, which I was coming to, has been an order where the RP, or in that case, the resolution applicant had received a favorable order from the PML authority. And that was challenged by ED before the. So what I'll do along with this attachment, I'll also share all the orders which are referred, plus the order which you wanted, that PMLA appellate authority passing an order in favor, that also I will provide for. Now, based on, well, like before the session, I've spoken to one of the counsels who was appearing before the PMLA authority. Now, I was briefed that the PMLA authorities also are now well aware of the fact that there is a statutory protection under IBC and are a bit lenient in terms of passing an order, but not during the process, but after the process is complete and the resolution has been passed. So the idea is that ultimately the ED attachment of a particular confiscation of a particular property, like for example, ED has attached, let's say, certain books and computers or things like that. The reason for that can be to further investigate on that and try to get back to the RP or to the CD or to close on their prosecution. So such things, even the PMLA authority does not want the ED to stop, because that these kind of investigations will further give clarity on what level of fraud had happened. At the same time, where there are real assets which are part of the resolution plan, which is approved under the CIRP, only subsequent to that, the PMLA authorities are willing to hear out the cases in terms of releasing of the attachments. Because during the process, the law is still unclear as to whether PMLA authorities can or cannot entertain such kind of applications by the RP. So that's the current situation, sir. As I was explaining in the beginning, there is no clear-cut position of law in terms of what is right and what is wrong. Purely based on the recent orders of the high courts, the RPs are expected to move forward and by ignoring the initial orders passed by various NCLTs. So as on today, even during the CARP, there can be attachments, and if we have to challenge on any ground, we'll have to go approach the PMLA authority and not the NCLT or NCLAT. And second clarity is by way of this March 1st, 2024 order of the Bombay High Court, where an order for CARP resolution plan has already been approved by the NCLT. It is clear, at least as part of this order, that the NCLT can firstly give a direction for release of the attachments, and the ED is bound to release such attachments upon a communication is being made to the ED. So that's about it, sir.
So that is regarding Mr. Shiv Charan and others versus adjudicating and that order
Correct,
you are saying.
correct. The Shiv Charan case law.
So, another thing, if so, is there any Supreme Court decision on this? Whether because this is contravening the IBC code that Section 14 is being actually superseded by this Bombay High Court decision. So, if there and it will be next to impossible that if any asset is attached by PMLA code to get a resolution applicant for that.
That's true.
Uh,
That's true. So
so
this is the Supreme Court order. In one of the it's like in 2022 December this order has been passed, but there is no final ruling again in this order till date. So in this, what has been held, a similar situation, and subsequent to this is like during CARP the asset was attached by the ED. So the RP had filed an immediate application before the authority and then made a mood, and they moved a special leave petition before the Supreme Court. And in the Supreme Court, the prayer was to allow the RP to conduct and conclude the process on as is various basis and whatever there is basis. So the idea is that merely because of attachment, the process should not stop. And the Supreme Court also, as an interim relief, has permitted the petitioner to conduct the process on as is various basis, and to make it clear that they have to list this plan before it is being approved by NCLT. So ideally, the Supreme Court is also yet to conclude completely on the position of law with respect to this. However, coming to Section 14, the observations have been made that because this is a special, even PMLA is a special legislation, merely relying on Section 14 should not be right, is what technically it has been held, sir. If you see this particular ruling of the Delhi High Court, it says that the power to attach under PMLA would not fall within the ken of Section 14(1)(a) of the IBC. So the idea is to say that PMLA is a separate legislation with a separate power. So per se, by virtue of moratorium, there cannot be said to be a release of attachment under PMLA. And any such relief which you need under PMLA shall go by way of an application filed before the PMLA authority. So that's the position of law as of now, sir, considering this Delhi High Court orders. But yeah, as you were asking, there is no such clarity from the Supreme Court in terms of how whether or not this is correct, wrong. We are still awaiting it. As I was explaining you that case.
what the Supreme
Yeah.
Court ruling you are saying? Can you please
Nothing,
write
sir.
it?
In the Supreme Court ruling, you want the citation? It is
Yes.
in Ashok Kumar Saravagi versus ED and another. It is a special leave petition number 30092 of 20. I'll circulate this along with the PPT, sir. You will get it from the ICSI.
And NCLAT also is saying that we will have to go to PMLA court for that for getting the seizure
Yes,
or
yes,
confiscation removed.
yes.
So
I'll show
so
that.
it
Yeah,
will also increase the litigation cost in the process, and also at
100%,
the same
100%, sir.
although also at the same time it will decrease the value for the stakeholders. Uh,
100%, sir.
and what I'm saying that how much time is taken in PMLA court, and what are the authorities in PMLA court PMLA court, after that PMLA appellate court, I think, and
Yes.
after that.
So firstly, there is a sessions court, sir. Your railway designated sessions court will act as the special court to decide on the cases under PMLA. And on an appeal, they go to the PMLA appellate authority, which is in Delhi. And subsequent to that, there is an appeal either to the high. I mean that's when you will go to the high court. So in PMLA, particularly with respect to these kind of issues, these are again summary proceedings, just like how NCLT are. So though the time taken is not extremely high, but at the same time, since there is no clarity on how or because sir, on one hand, today we are professionals under IBC, so we have our grounds as to why IBC shall prevail and why IBC has to be looked into. Similarly, if you look at the role of the ED does not want any such criminal assets, as the proceeds of crime to be simply carried forward by any other party. And like for example, any asset, like let's say there's a factory and it has been attached, and let's say all the money invested in it has been a proceeds of crime. Now it means indirectly you are literally passing off an asset to somebody which is a proceed of crime. So there is no possibility of recovery at all for the ED. At the most, the promoters definitely will be there, but what if the promoters' assets or anything is not available? So technically, even ED is in a position not to simply give away to whatever has been provided for under the code. At the same time, the code is well aware of the fact that the assets they talk about are the assets of the company which has certain business. So ultimately, if you look at, sir, if ED is attaching an asset in confiscating and let's say they are recovering from it, it goes to the government. Now, the government itself, by way of the law, is trying to say that fine, instead of we taking over by virtue of this, we don't mind if a new party is coming and running it and making business out of it and paying us taxes. We are okay with it. So I personally feel that's what is the intention of introducing Section 32A, to say that, yeah, as you rightly pointed out, if there is an attachment and there is too much of litigation, that's going to cause a lot of problem and decrease in value. So, sir, in such a cases, if this kind of a clarity of Shivcharan is upheld by the Supreme Court, if Supreme Court upholds this order, then as an RP, we need not even litigate during the process. During the process, we simply have to give an assurance to the RA that, see, this is the Supreme Court order or that Bombay High Court, as of now, the Bombay High Court order. But if at all it is upheld by the Supreme Court, we can say this is the Supreme Court order. So once the plan gets approved, the 32A will be operative and all these attachments will be released. Now, if that kind of a certainty is there in the market, then definitely we will not face the problem of decrease of the values. But if this clarity is, let's say tomorrow Supreme Court keeps it on hold or stays the operation of this order, then again it will go back to square one and it will again cause a lot of confusion to the RA. I was explaining to that case, no, sir, that JSW, where even today they are still fighting out with the Supreme Court in terms of questioning the authority of ED to continue the attachments. Now, if by virtue of this order, if this is also being appealed, probably Supreme Court will hear all that appeals together and should be this year. It is expected that a ruling will come from the Supreme Court clarifying the position of how the PMLA will operate, particularly in cases where the companies are undergoing CARP.
And while doing this, while giving this decision, it
So,
was also mentioned that RDBA is
uh-huh.
also a separate authority. So RDBA has also given power uh, by that ruling, no? That
The recovery of debt due from banks, that part you're talking about, sir.
yes, no, you are saying that Bombay High Court ruling,
Ah,
in that case, PMLA, RDBA, SARFAESI Act, Insolvency
yeah,
Code
yeah. This is the Delhi High
co-
Court order, correct? Ah,
coexist. That
correct.
means RDBA now also can contravene this section 14. That is,
No, 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 sir. No, no, no. That's not the interpretation. Here, of course, they're just trying to say that where there are assets involved, where there is a recovery involved, all these acts will not override each other. They all will coexist. No, that doesn't mean that if there is a inconsistency between RDBA and insolvency code, then RDBA will prevail. That's not what it is trying to say. Ultimately, where there's an inconsistency between this with IBC will definitely prevail. But let's take SARFAESI as an example. Well, let's say the bank has already initiated sale under SARFAESI, and before the bid has come, the company has entered into CARP. Now the bank cannot go and say, no, I will continue my bid and I will, purchase the asset under SARFAESI. The bank cannot say so. I'll sell the asset under SARFAESI, because the moment CARP comes, the Section 14 moratorium will definitely come against such kind of an activity of recovery by a creditor. Because Section 14(1)(a) very particularly says recovery by a creditor. The language is very clear. However, for PMLA, it's neither a creditor. It's not a creditor. It is a government investigation authority, and there's no specific provision under 14 barring them from attaching or going ahead with the property. The language of Section 14 is not actually intended to talk about investigation authorities. Either it is not envisaged or it is not intended. So that's the reason why there is a confusion. Otherwise, there is no such kind of a ruling to say that Section 14 doesn't apply for RDBA or SARFAESI. No, that's not what it means.
This
Yeah.
is overactivism by Delhi High Court, because PMLA there is some logic that proceeds of crime has been
Correct.
given inducted into to the company. But why RDB and SARFAESI also had been
No, I'll tell you. Actually,
put on the same footing of PMLA? That is really
no, sir. Actually, sir, no. This you are reading this as PMLA, RDBA, SARFAESI versus IBC, but that's not how it is done. It is other way around. They are trying to correlate these acts with PMLA. So in this Delhi High Court order, it is the ED which has initiated this. So ED is particularly concerned about PMLA. Now, in this, the facts are that there are multiple appeals in the same case. The facts are, a brief fact is that few creditors are arguing on the fact that there are certain assets for which they have every right to go for enforcement under SARFAESI. But the same asset is being attached by the ED. Now, there the question of SARFAESI versus PMLA is coming. Similarly, RDBA versus PMLA and IBC versus PMLA. So, you are reading it as PMLA was IBC, RDBA was IBC, and SARFAESI was IBC. No, that's not what is the ruling here. The ruling here is actually IBC vis-a-vis SARFAESI. Sorry, IBC vis-a-vis PMLA, SARFAESI vis-a-vis PMLA, and RDBA vis-a-vis PMLA. Because the difficulty of attachment is there for all these acts. And today, let's say the company is not in CARP. I am a creditor. I have a right over a property. I can enforce the security interest, but the same asset is under attachment by the PMLA or by the ED. Now, that causes a difficulty to the creditor to enforce the security interest and sell the asset because it is under attachment by the ED. So, there they are trying to interpret the laws to say that, even SARFAESI has a non-obstant clause, or PMLA has a non-obstant clause. So, but they try to say, see, these all have to be dealt with together. But where there is a mischief established by way of process of crime under PMLA, PMLA will definitely have a jurisdiction to play, is what the ultimate ruling of the Delhi High Court is. So they're not actually overboarding themselves to link SARFAESI with IBC. They're linking all these acts with PMLA. They're reading it alongside PMLA, not with IBC.
Now, in proceeds of crime,
Yeah.
how it can be determined? Because if a company has no business, only money has come in and money has gone out, then yes, proceeds of crime can be that theory can be established. But if
Yeah.
a company has also business is also in business, and so proceeds of crime has been inducted into business, there is some business income. So how these proceeds of crime can be determined?
Correct, sir. Sir, usually what happens in PMLA and this ED, PMLA Act per se is that firstly, what all attachments we see are attachments under Section 5, sir. So Section 5 attachments are provisional attachments or final attachments merely based on suspicion and certain investigation which they do in terms of flow of funds. Now, what they do is the company has got certain assets and the company is involved, let's say, in a criminal activity. So they'll first confiscate the asset so that they will, first attach the asset so that they will start investigating further on it to realize whether this is a proceed of crime or not. That question comes at a latest point in time. But even if there is a hunch that there is a possibility that this process of crime has been invested in this particular asset, they'll immediately catch hold of that particular asset. Second, how I'll tell you, sir. For example, let's say there's an asset valued very low. Let's say it's a very normal asset or maybe very high, but you have brought it at a very lower price. No, that can also be a very indicative made that, okay, you would have made the payment in some other mode and you have taken over this asset at a very lower price. This can also be a proceed of crime. Now, if there is such kind of a substantive evidence with the ED, they will immediately attach a provisional and then confirm the attachment by the PMLA, by the sessions court, and subsequently they will prosecute. And this prosecution is a time-taking process. That's what you're asking about. How do you determine it is a proceed of crime or not? That is done by the ED using their criminal law provisions, and they will do a prosecution wherein they will investigate the promoters, they will look into the books of accounts, bank account statements, deviations of funds, subsidiaries, parent companies, bank accounts across the country or abroad, assets of the promoter, assets of the promoter's immediate relatives, or even promoters, staff, housekeeping, everyone will be completely scrutinized. And then subsequently in this prosecution, they will invite all of them to the prosecution. I mean, like they will rather not invite. Obviously, they'll get the appearances of all of them before the court, and then subsequently record their statements and conclude whether it is a proceed of crime or not. If yes, they will confiscate the asset. If no, they will release the asset. This is the procedure. But IBC comes in between when the prosecution is on. So that's where this Bombay High Court order also is trying to say in Shiv Sharan case that if you read the order, sir, in the reasoning, they try to say that the moment Section 32A comes into picture, you are saying under 32A1, there cannot be any prosecution and the liability shall cease. So which technically means you cannot confiscate. So tomorrow, if for a property which cannot be confiscated, why should the attachment be in force? So the attachment shall be released. That's how the Bombay High Court had interpreted this 32A to give relief, to give the actual interpretation and the intent and meaning of Section 32A.
So, and during the process, CRP process, how that seizure, can be seized, assets can be seized by ED during the
Yeah,
process.
they can attach the assets. As of now, that's what the law says. Like even during the CIRP, the ED can still attach the assets, because even the Supreme Court order which I was referring to, in that the attachment had happened 2 years after the commencement of CIRP.
Okay.
Yeah. So it and the Supreme Court did not immediately pass any passing remark as well. If you see this order, it very clearly says on 30th December 2021, the ED issued an order, and it says that yeah. Therefore, we are dealing with a fact situation where the order of provisional attachment was passed more than 2 years after CARP was admitted and 1 year after invitation was expression of interest was published by the petitioner, that is the RP. So, Supreme Court was also aware of this fact, and Supreme Court did not immediately say this is wrong. How can you do it? It indirectly means there is an indirect opinion that yeah, it may still be done. It has to be analyzed. So this is, I mean, there is no complete end of position in terms of whether or not they can do that is still yet to be seen. But as of now, yes, definitely ED will have the power to attach if they have a ground to do so. However, as an RP, it might be, I mean, but you're right, the kind of money we have to invest in it, the kind of resources we have to bring in, that also matters a lot. If it's a big matter where we have good backing by the COC, then yeah, maybe we can get a senior counsel, go to the PMLA, and at least make sure that no attachment is happening, or there's a status quo on the attachment. That can be done. But if such kind of a support system is not in place, then yeah, you're absolutely right. So it becomes very difficult for the RPs to manage such kind of a situation unless these kind of orders are interpreted and implemented strictly and are upheld by the Supreme Court.
So the only way out is that if anyone would take the property at a throwaway price, then only immunity is there. The resolution applicant has got the immunity. Otherwise,
Correct.
everyone is uh, actually open for this PMLA intervention.
Yes, sir. Absolutely right. As
Okay,
of now, that's how it looks like.
as of now. So it has not yet settled in
Mhm.
Supreme Court.
Not yet, sir. Not yet.
Okay, okay. Thank you very much.
Thank you so much for all such interesting questions, sir. Extremely helpful for the forum, I'm sure. Do we have any other questions, or anyone wants to put forward any other thoughts? We can take it up. If not, we can conclude the session. Okay. Well then, Ranjan Chakraborty sir, thank you so much for the interaction. It was really nice all the way you have discussed and interacted with me. Extremely thankful to you. And thank you so much to
And thank you
ICS.
to you for giving such a good situation-wise all the interpretations. Thank you
Sir,
very much.
thank you so much, sir. And I'd also like to thank ICSA IPA for Institute of Insolvency Professionals for giving me opportunities on continuous basis to share my views with the forum. So with this, we can conclude the session, and over to you, Anjali.
Sir, if you want, you can discuss more case laws.
I can share the case laws. We have already discussed all the case laws. I can share this PPT and all the relevant material to all the audiences. They can look into it.
The Supreme Court
Thank
case
you very
also.
much, sir.
Yeah, definitely, sir. I'll share all that we have discussed. The Supreme Court and the unclad order also has not come in the
Yes,
presentation,
yes,
which
yes.
we discussed. I will share it. Yes.
Thank you very much. Thank you.
Thank you, sir.
Thank you very much, sir, for taking out time and giving such a knowledgeable session. And sir, you are requested to please share the PPTs with us.
Thank you, ma'am. Thank you so much. Anjali, can I exit?
Sure, sir, sure.
Yeah. Thank you.
And participants, the session is completed. Now you can leave.
Yes, thank you.